So you see, Colonel, you have violated the Constitution in what I consider a vital point. It is a precedent fraught with danger to the country. For when Congress once begins to stretch its power beyond the limits of the Constitution, there is no limit to it, and no security for the people. I have no doubt you acted honestly, but that does not make it any better, except as far as you are personally concerned, and you see that I cannot vote for you.
Welcome to an episode of Sittin Rambles. I know it's kind of strange. I'm here at Freedom Park in Liberty, North Carolina. It seemed like the best place to do this. I'll keep this one nice and short. One of the problems that a lot of people have had lately is understanding constitutional language. The problem with the Constitution is that it was written in 1776-ish. You know, I don't remember the exact year. It's been a bit since I took a civics class, but late 1700s. Now, the further back you go with the English language, the worse things get, because the further back you go, the less English sounds and looks and feels like what we have today. For example, they used to spell fruits with an E. I don't see how you would do that. They used to capitalize like every third word. It wasn't that it was every third word, but it was almost like title case, except that was everything. Everything, imagine everything written in title case, where all of the less important words are lowercase at the start. You get the idea. The problem with constitutional language is that we are about, as of this recording, 249 years removed from it. And while some things are still the same as they were almost 250 years ago, a lot of them are not. For example, the biggest problem with constitutional language that most people run into is understanding the Second Amendment to the United States Constitution. The Second Amendment says oh crud, as soon as I get in front of the camera I forget it, because that's what nervousness does. I love cameras, don't you? The Second Amendment of the Constitution states a well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. Each one of those sub-sentences has a comma at the end. A well-regulated militia, comma, being necessary to the security of a free state, comma, the right to keep and bear arms shall not be infringed. Many people have chosen to incorrectly interpret this as the Second Amendment only grants you the right to keep and bear arms if you're part of the militia. First of all, the militia in the 1700s was the people, basically any able-bodied male, generally between like 25 and 40, any able-bodied male that could wield a firearm had to. And in fact, there was a point in time in the history of the nation where you were required to keep and bear arms. It wasn't just that you had the right to, but everybody was kind of expected to have some sort of armament to defend themselves and their neighbors. It was normal 250 years ago for everybody to have a gun or a knife or a club or an axe or whatever to defend whatever. The community, themselves, their children, you name it. It was pretty much a universal expectation. I don't know that it was a legal requirement, but it was pretty much required of everybody. That it was just the norm 250 years ago. Today, for some reason, when seconds count, the police are minutes away, yet somehow we have falsely misinterpreted all of the laws and the Constitution to say, oh, you don't have the right to keep and bear arms unless you're part of the militia, which we have just decided means the military, which there wasn't really a U.S. military back then. It was all a bunch of loosely organized people. Basically, every able-bodied male in the community would have a gun, and that made them part of the militia. Every citizen, potentially, was part of the militia. The militia is not the military. These are different terms. They didn't say military because it wasn't the military. A militia is not a military. Things have changed quite a bit in 250 years. And I'm going to keep saying 250 even though it's 249 as of this recording. I think you'll get over it. But that's the problem with the Constitution, with reading the Constitution, is that it was written a long time ago. Things don't work the same way that they used to. So what is a well-regulated militia? If it's not the military, then what does that really mean? A well-regulated militia, you have to look at what the words meant 250 years ago. Regular, while here we think of regulation as laws, a regulation is effectively, for simplicity's sake, a law. It's a rule that has the effect of law and often is backed by a law. But in the past, 250 years ago, regulation meant regular. For a militia to be regulated, it didn't mean the militia was bound by laws, that it was set up and it was in the architecture of it was legal. It meant that the militia was made regular. Back in the day, regular meant that something was in good working order, that it was functioning as expected. That is very different from, oh, it's a law, or it's a rule that has the effect of law. That is not what we think of when we think of a well-regulated militia. We don't think regulated means in good working order. We think it means that there's a law on the books or a rule that has the effect of a law on the books. The problem is the Constitution wasn't written today. The Constitution was written 250 years ago. So, 250 years ago, it meant regular. It meant in good working order. And besides, if you take into account the commas and the structure of the sentence, the Second Amendment has a clause at the beginning that says, hey, here's the reason for this, the rationale. Here's why we did this. A well-regulated militia, a bunch of people who are capable of defending the country, their land, their home, being in good working order, meaning they're capable of being the defense force, being necessary to the security of a free state. The United States can't exist without a bunch of people that can defend it and that are capable of doing so. The right to keep and bear arms shall not be infringed. So the beginning is a purpose. It's an explanation. This is why we're doing this. And then the ending is, if someone has an armament, if someone has a gun, a cannon, whatever, if someone has a weapon, the state can't do anything about it. That's it. Shall not be infringed means the government cannot make any kind of law that infringes upon the right to keep and bear arms. I should be able to have a gun, and the government shouldn't be able to do anything about it. If it was written in modern parlance, it would be, it's important for us to have people that are able to defend the country and their communities. Therefore, the government cannot do anything about you owning any kind of armament. We'll workshop it, right? But the other one that has become more contentious as of late, as the gun control debate is starting to die, more and more places have constitutional carry. Ultimately, I think eventually we'll get to where the Second Amendment is understood and interpreted appropriately. But the most recent thing as of this filming has been the concept of due process. First of all, due process means the process was followed. It doesn't mean very specific things. Due process means the law, that, whatever the laws are in the books, the laws lay out a process. This is the process. This is how it works. You cannot be deprived of your life, liberty, or property without due process. And boom, here's how it works. This list of things, this is how it works. The problem is people interpret this as, well, every single person always has the right to this specific set of things. That's not how it works. See, due process is one thing, but the thing that invokes due process is another. And here's the problem. If you're a U.S. citizen, or if you're in the U.S. and you break a law, let's say you steal $1,000 from someone at gunpoint. If you break that law, the United States can charge you. You have the right to a speedy trial by a jury of your peers, you know, the whole shebang. If you look up Miranda warnings and stuff, you can understand exactly what it is that you're allowed to have if you commit a crime. But in this specific instance, we are discussing not somebody violating the law as in like a state statute or whatever. We're discussing illegal aliens. Now, when an illegal alien does something, they don't get due process that is the same as if somebody, say, you know, shoots up a shopping mall. So if an illegal alien commits a crime, they go into the justice system and they're tried for breaking the law of the land. But if someone's just here illegally, and that's their crime, is that they're here illegally, which is a crime. I don't care how many times CNN lies and says, oh, that's a civil. That's not criminal, that's civil. No, illegal. It's not a matter of civil. If the government's coming after you, that's not civil. Don't give me that crap. If you're here illegally, then your due process is you're gone. And that's it. Now, you have one remedy if you are here illegally, and that is you can file a writ of habeas corpus in the court system. And if you file that writ, then the court system is obligated to hear you out, because a writ of habeas corpus cannot be ignored. I don't remember the exact language, but in the Constitution it says you can file a writ of habeas corpus and the government can't ignore it. In fact, one of the components of our Constitution is you have the right in the First Amendment to petition the government for a redress of grievances. And this applies to everyone. However, the thing is, this is different from due process, as in like you're charged with a crime, you automatically get a trial. If you're here illegally, that is not the same thing as all the other crimes. If you just walk across the border, you don't then get to stay here for years while we decide whether or not we can kick you back across the border. That's not how that works. If you're here illegally and we're going to kick you out and you don't think that you should be kicked out, you can ask the government, you can send a letter to the government, file it with the court saying, this is a writ of habeas corpus. I am demanding that the government answer for this. You know, you're trying to get rid of me, but you don't have the right to do that. And then the government does have to go through the same process. They have to hear your writ, you know, gather evidence and all that. It basically is the same thing as if you were charged with the crime. But just coming across the border illegally doesn't entitle you to the entirety of the access to the court system in the United States. And that's kind of the problem with constitutional law. See, one of the things that people hinge all this stuff upon is that there is language in the Constitution, I believe in the 14th Amendment, that says that that these rights apply to blah, 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 and people subject to the jurisdiction thereof. This is the second point that I'm trying to make with this video, is that subject to the jurisdiction thereof does not mean what it means today. If I was to say today that, oh, well, I'm here in Liberty, North Carolina. I'm under the jurisdiction of Liberty, the town of Liberty. I'm under the jurisdiction of Randolph County, North Carolina. I'm under the jurisdiction of the state of North Carolina. I'm under the jurisdiction of whatever the court districts are. I admit I don't know exactly. I'm under the jurisdiction of the federal government. I'm under the jurisdiction. There's a lot of things that I'm under the jurisdiction of when we're talking about the courts. So what court system are you under the jurisdiction of? What, you know, legal system has power over you? And that's the fundamental problem. Subject to the jurisdiction thereof does not mean whether or not you're under the power of a court system. When they wrote that amendment so very long ago, that is not what it meant. And there are several filings, and there's even a case from, I think, the early 1900s that tests this exact thing. So if you go back and you look at the cases, I admit I don't remember the name of it, but there was a case from the early 1900s where someone who was here as a lawful permanent resident was, I think, going to get kicked out, and they were challenging it, and the court ruled they could stay. And the problem is that people do not seem to understand when they justify this notion that jurisdiction just means that you're subject to the laws. That no, even case law says that's not what that meant. When they were discussing the amendment, when they were, the information that clarifies what the amendment's intent was, does not say that. It's anybody who is here, who is a citizen, a lawful permanent resident. Basically, if you're here legally, then you are entitled to due process. But if you're here illegally, it was never intended for that. The whole point really was to make it so that slaves who were brought here against their own will could become United States citizens by virtue of having been brought here against their will. It was basically reparations for slavery. But we can't take these reparations for slavery and suddenly just apply them to any old idiot who walks across the border because demented Joe Biden decides, oh, I'm just going to let everybody in the country. And, you know, even though all of those people just flooding in the country, that's a violation of the laws of the country. There was no due process involved in them coming into the country. But I'm just going to let them all in anyway, in violation of due process. So the problem is, if somebody comes here illegally, they're not entitled to the same due process that you get if you're a citizen, a lawful permanent resident, a lawful visa holder, etc. If you're here illegally, and they know that you're here illegally, there's no social security number, birth certificate, driver's license, there's no proof that you're here legally. If the facts say you're not here legally, you're gone. And your due process is that you can file a writ saying, hey, I'm being kicked out, but that's not okay because I'm not supposed to be kicked out. They don't have the right to kick me out. I'm a citizen, or I'm here lawfully and they made a mistake, or whatever. That's your due process. But you don't just get kicked into the court system just because. And this misreading of the Constitution is the fundamental problem with that. The whole point of this video is that if you are going to read the Constitution and understand and interpret it, you have to understand and interpret it as they meant back when they wrote it. You can't say, oh, well, the meaning of the word has changed, therefore the meaning of the document has changed. The Constitution is not a living document. As Ruth Bader Ginsburg, who thankfully is dead, famously said, Ruth Bader Ginsburg was a terrible Supreme Court justice, and her whole living document notion was complete BS. The Constitution was very carefully crafted by a lot of very intelligent people who had suffered through some very severe abuse from Europe, from the UK, England, whatever the hell it was back then. They suffered from a lot of abuses. They knew what it was they wanted to do. They knew that they wanted to have freedom from religion, not just freedom of religion. They knew that they wanted taxation to be followed with representation. You can't take from us without us having a say in what you're taking, how you're using it, etc. And they did not pick their words lightly. This stuff was architected very specifically. And if you're going to read it, you have to read it as it originally was written. Now, one more thing, and then I'll go. This is also often the argument used against the Second Amendment. Oh, well, they didn't intend, like, when they wrote that, they were talking about muskets. So the Second Amendment only applies to muskets. Except that's not what the Second Amendment said. If the Second Amendment was supposed to apply just to muskets, then the Second Amendment would say the right to keep and bear muskets shall not be infringed, or it would have an enumerated list, or it would have some sort of list of specifics. The Second Amendment, much like the First Amendment, neither of them have anything in them that grants exceptions. The government cannot make laws prohibiting these things, and that's the end of it. And that's it. Constitutional speech, you have to understand it in the context it was originally written. Thanks for listening. Like, comment, subscribe, and all that crap. And remember, this is actually a podcast, although I'm not really rolling since I'm kind of sitting. So, but hey, you know what? Rollin Rambles at 0 miles an hour works for me. Tell me what you think in the comments below. Take care.